My name is Joe Schulle. It's S-C-H-U-L-L-E. I'm the president of Local 22, the Philadelphia Firefighters and Paramedic Union. As the president of the International Association of Firefighters, Local 22, on November 11, 2013, I asked the Philadelphia District Attorney, Seth Williams, to investigate our allegations that both Fire Commissioner Lloyd Ayers and Fire Department Human Resources Manager Karen Hyers committed perjury before Judge Tucker in Common Pleas Court on September 25, 2013. We do not take making these very serious accusations lightly. Accordingly, we provided the District Attorney's Office with a substantial amount of supporting documentation. Based on the documentation we compiled, we are also alleging that the Commissioner and Human Resources Manager conspired to provide this false testimony. As I will outline, not only was their testimony clearly false, it was also nearly identical and intentional. On September 25th, we went to Common Pleas Court in an effort to stop the city from demoting 14 Local 22 members. During the course of the proceedings, Lloyd Ayers and Karen Hyers provided false testimony under oath. We understand that perjury is more than simply proving that false testimony was provided. We must also show that it was known to be false and it was material to the proceeding. Both testified under oath that all the interviews and promotions were conducted on May 30th. The reality is not one interview or promotion was conducted on that date. Commissioner Ayers and Ms. Hyers may contend that they simply confused the date. But considering that the interviews and promotions actually took place on 7 different dates over a 10-day period beginning on June 3rd and ending on June 13th, would a reasonable person conclude that they confused conducting interviews and promotions in one day when they actually occurred over a 10-day period? We believe that this was their first deliberate attempt to mislead the court. Both testified under oath that they informed each and every member to take the upcoming promotional test scheduled for June 8th. 7 of the promoted members were interviewed after the June 8th test date. Again, they may contend that they didn't know the date of the promotional exam, but is it possible to believe that they instructed these 7 members to take the test after the test date and not one of these members informed them that the test date had already passed? The reality is that they provided this false testimony to cover up the fact that they did not give these members the opportunity to take the upcoming promotional test. We believe this was their second deliberate attempt to mislead the court. To further illustrate the point, Ms. Hyers was not present for 4 of the interviews conducted on June 6th and June 7th. So, not only was it impossible for her to tell the 7 members interviewed on after June 8th to take the promotional test, she could also not have told the 4 members on June 6th and June 7th because she was not present. Again, would a reasonable person believe that she simply made a mistake? No. Her false testimony was deliberate and intentionally misleading. On a final note regarding Ms. Hyers, I asked her directly at the promotional ceremony on July 17th if these men would be demoted, and she stated that they discussed it and decided it would be in poor taste. This statement was very similar to the multiple statements she made to the 14 members during their promotional interviews. In addition to the testimony before Judge Tucker, Commissioner Ayers also testified before City Council on October 30th. What's interesting about this testimony is that he twice said he needed to refer to his calendar to confirm the exact date of the interviews and promotions. In his second statement, he said, "I'll have to check my calendar to see if any of those interviews were interviewed after the date." Clearly, from that statement, he knew he interviewed these members on multiple dates. He would have to know. The interviews took 10 days, not simply one date. Commissioner Ayers even took it a step further during questioning from Councilman Kenny. The councilman asked, "How can you say under oath that you met with these people before May 30th when you didn't? It's in the testimony." Commissioner Ayers responded, "I didn't have my calendar in front of me when I testified either, but it was not an intention to make something different or make the situation different." This statement was referring to his Common Pleas Court testimony. Then, moments later, he reverted back to his original testimony that he interviewed and promoted all the members on May 30th. Commissioner Ayers knew in counsel that he did not interview all these men on May 30th, and he knew it during his common pleas court hearing. Yet he still testified to it twice. Commissioner Ayers testified under oath that he told each and every member that they would be demoted should the ruling go in the city's favor. Nearly every member provided a statement contrary to Ayers' testimony. Commissioner Ayers testified under oath that he provided the letter from the law department dated May 30th, on May 30th. This is not true. Commissioner Ayers testified under oath that he interviewed and promoted all 14 members on May 30th. This is not true. Commissioner Ayers testified under oath that he instructed each and every member to take the upcoming promotional test, even though the overwhelming evidence indicates that he interviewed 7 of the members after the promotional test date. It is our strong contention that Fire Commissioner Ayers and Ms. Hyers knowingly and willfully provided nearly identical false testimony in common pleas court. We believe the documentation we provided to the DA and you here today clearly supports our position. Their testimony was false and it was knowingly false. The final question is whether the testimony was material. Judge Tucker specifically identified the members' knowledge and ability to take the June 8th promotional exam in formulating his decision. That alone makes the false testimony from Commissioner Ayers and Ms. Hyers material. The testimony from Commissioner Ayers and Ms. Hyers fulfills all the requirements of perjury. They deliberately impeded the court in its ability to find the truth. We believe they should be held accountable. We are truly grateful that District Attorney Seth Williams is carefully reviewing these allegations and contemplating an investigation of possibly perjury committed by Commissioner Ayers and Ms. Hyers. Finally, we would like to ask that the media please consider all the information provided, especially when the city responds to our statement. Thank you for your time, and I can answer any questions.
What's the incentive on this? Is going to be basic. What's the incentive for Ayers to lie under oath? What does he get by doing this?
He gets what he wanted, and that was to demote the 14 members. So, and that's what our contention is, that had he given the accurate information, the judge would have ruled that it was improper to now demote these members because they weren't given the opportunity to keep their career progression going.
And what do you then view, what do you think of a fire commissioner who you're alleging now is perjured himself, is in essence lied under oath? And what's your view of him and his actions?
I believe he broke the faith. When we swear an oath to take a position, whether it be a firefighter, lieutenant, captain, all the way up to the position of commissioner, we swear an oath aside from the oath that he swore in Commonwealth Court, or Common Pleas Court. And he broke the faith to every member of this union, every member of the Philadelphia Fire Department. He holds us to a higher standard. He holds the rank and file members of Local 22 to a higher standard. That we have to tell the truth at all times. And so how are we supposed to have faith in a commissioner that feels that we have to tell the truth, but he does not?
What do you hope for the
Well, our end game has always been the same. We want to see these 14 members restored to their position, as they should be. And we're hoping that this will show that their testimony was false, and that directly related to the judge's decision, and that the city will acknowledge that and restore these men back to their positions.
Where does your case currently stand? Were you guys in an appeal, or is this sort of a last effort?
No, we actually have a motion for reconsiderment at the Commonwealth Court level, and we also have documents filed with the Supreme Court. So we are going about this every different angle that we can find, and this is the most significant for us right now because this played a major factor in the judge's decision, and it's simply not right. The court, anything you read about the court, their job is to find the truth. And if we have city officials that are knowing and willfully providing false testimony, how can the court come to an accurate decision?
Have you had any contact with Williams' office? Have they asked to interview your members yet involved here? What do you know about the nature of this probe?
I have spoke to the district attorney about filing this, and he welcomed the information and said he'll review the information and he'll assign it to an investigator, and they will proceed once they go through all the documentation.
Joe, do you know what role, if any, the judge that heard this testimony in Common Pleas Court, what role this judge might have?
Well, I understand that the judge can, from the bench, charge with perjury. I'm not sure if we can do it after the fact, but we are going to get all this information to Judge Tucker so that he will be at least know what was testified and what is the truth and what is in fact not the truth.
Can you spell your name one more time?
Sure, it's Schulle.
Any other questions? Thank you guys very much.
Thanks for coming out, guys. I appreciate it.